It was really interesting to hear about all these questions that you raised. Does our audience have any questions right now? Does anyone want to start, or should I use my privilege as the moderator and go ahead and ask my question? Mm-hmm. Okay, then I'll go ahead, and in the meantime, please, our online audience, please feel free to write your questions, or you can also turn on your mic and ask them. So my question is, you mentioned, you talked about this division between the Law Enforcement Directive and the GDPR, and how they have different levels of protection towards the individuals. Mm-hmm. And how, when private companies are developing the technology, GDPR applies. And I automatically thought about our projects, of course, and in some cases, in many cases, private companies are developing these technologies, but then law enforcement uses the said technology. And in the end, where do you think, I know this is a question that's still up in the air, like where to draw the line, but I wanted to hear your initial thoughts about it. Maybe how should we draw the line here?
That's a great question, because it gets very complicated sometimes, especially. By the way, I should also underline, if a member state has a foreseeable law making a private entity responsible for crime prevention, let's say, then it doesn't have to be law enforcement, but this kind of entities foreseeable, which are foreseen by law as competent, if they collect data for crime prevention or crime detection, they are also within the Law Enforcement Directive. So, but we don't see it in most of the cases. Like, all the names of the companies that I mentioned are just private companies, entities which are not foreseen, which are not competent for crime prevention. But sometimes we already know that these companies have the intention of selling this kind of technologies to police forces from the beginning. So by definition, they are within GDPR, but having something like, if they work in line with law enforcement, even during developing these technologies, maybe we should also think about enforcing law enforcement if the law enforcement is also working directly with the companies. Maybe in that case, I think it's more like becoming a public field than just a private companies developing technologies field. But it's maybe better to have in between norms, especially about the right to access to data by law enforcement, because when the companies just collect this data and share it directly with law enforcement, then it's kind of data collected within GDPR is automatically shared with the law enforcement. So it's also a bit complicated, because if you don't regulate the right to access by law enforcement in a foreseeable way, then it's like circumventing law enforcement in a sense. And more important than data protection rules, it's circumventing criminal procedure rules. Because to go to someone's house, you get permission from the judge and you should have reasonable suspicion. But if you have already data collected out without enforcing these measures, then you circumvent the measures and the protections of the measures in the criminal procedures. That's why it's really crucial, not only from data protection point of view, but from criminal procedure point of view, that's how you access this kind of data, which is already collected beyond the investigation. So my answer is all these regulations might still have loopholes, and we should fill them by having foreseeable laws.
Thank you. Amazing answer, really. In the meantime, I see that Khalid from our online audience asked if there are any decisions on this issue by the CJEU or the European Court of Human Rights.
I mean, of course, there are issues which might be relevant, which at least tackle with the data collection point of view. Like, you can't have an indiscriminately enforced mass surveillance, like Big Brother watch case, simply. So that there are cases which limit mass surveillance, but I haven't seen any case which tackles only with the profiling tools and which tells if they interfere with the right to privacy or with the right to a fair trial. So I'm looking forward to that too, and I'm trying to update myself on the decisions. But as said, I haven't seen any risk assessment tools related decision. If in the audience anyone knows more, I would be happy to hear too. And also in the Siri case, the case was about the collection of data and profiling tools, as far as I remember, to know who is going to commit tax frauds. And the court tackled with more the right to privacy and said, okay, there is no foreseeable law which says under which conditions Siri will be enforced, when the data will start, till when the data will start. So they found it not in compliance with the right to privacy, but it didn't tackle with the issue of right to a fair trial again. So I'm very curious to see a decision about the right to a fair trial.
Related cases, not specifically right to fair trial, but in the context of administrative decision making, there is Dutch case law. You probably know the IRIUS cases, where administrations used algorithmic decision support systems to either license. I don't remember which type of license, but it was either to construct a building or to use land for certain purposes, and on the basis of that system, the license was refused, and so the person confronted with a negative decision took the case higher up, and the court decided that there was no equality of arms because the system wasn't transparent for the citizen being confronted with the system. But apart from not in the criminal law context, I'm not aware of cases. Maybe they exist, but
actually, I may add something here.
Yeah.
Recently, the EncroChat cases, especially a court in Berlin, Germany, has referred an EncroChat case because how the data was collected. I mean, I don't remember the exact details and the exact wording, but because I don't know if our audience is aware of the EncroChat, but maybe I should give a short intro. So basically, the French police hacked a huge criminal network. Basically, some criminal organizations. It was suspected that they were using an encrypted device and an encrypted network. Like they had these phones, which looked like regular normal phones, but after like selecting an app on the phone, you were able to access a whole other network. And basically they hacked these phones. French police managed to hack these phones, and they collected a lot of live data. They basically millions and millions of data points. So what happened is, to be able to go through this data, they have to use machine learning and AI tools. And afterwards, the findings were used to initiate a lot of cases against these criminal organizations. And again, that information was shared with other countries, with Netherlands, Germany, Belgium, the UK, etc. And the defendants argue that they don't know how this data was collected. They cannot know. First, the French police argues that it is an issue of national secrecy, but also there is the problem of bugs, and like we cannot really know how this tool functioned to come up and to identify these specific instances of crime or potential criminal instances. So right now, one of these cases is referred to, I think, like there are some upcoming case law, let's say it that way. There is no final decision yet, but I imagine we will see some interesting decisions in the future.
But maybe country on the country-based level, there are decisions also, not with regard to criminal profiling, which is so complicated right now, but with simple data mining methods. For example, in Germany, the data mining discussion started with RAF case, where they tried to figure out where the members of RAF are living, and they figured out that actually they don't pay anything via bank. So they got data from people who pay their electricity bills and everything via bank, and they kind of outsourced the people who don't, and then they meshed it with other forms of data, and they made a raid to the right house. So it's the basic form of data mining, maybe. But when it got complicated, for example, in Germany, there was a case also with regards to profiling some students coming from some countries, thinking that among them there might be threat to public danger, there might be some extremists, but that was more complicated. They used data, not only regarding their lifestyle, associates, connections, and that made it to High Court, the Constitutional Court. And then they said, hey, there is no foreseeable law that you can do this. So you should have a legal norm which shows that for what kind of crimes you use these tools, and for who are your targets. You can't just say these students coming from this countries. It's like huge targets. So you should have at least a simple suspect that the person might be committing a kind of crime, or at least preparing. So without this initial suspect, you cannot start collecting all this data and then say, later on we can profile and use them. So it was one of the cases which really tackled with profiling. And actually, since we have a technical expert here, you are from computer science background, no? Can I ask like a very simple question? It's unusual for me to ask maybe questions, but I really wonder, because we keep reading about this black box and how it can be, like how we can use alternative decision tree making systems that shows what kind of data is used for what purpose. And it's always argued that the black box algorithms come up with more like true solutions compared to simple ones. Like since they are trained with self-learning algorithms, they correspond more to reality and they come up with more real solutions. But would you agree with that, or do you think they're irreplaceable?
I'm not an AI philosophist, right? And this sounds exactly like the question. No, I don't dare to answer that question. No.
Okay. Okay then.
But I have another one for you, just to fire back right away. So hi, this is Tobias. The AI Act that is upcoming, does it in any way restrict the kind of analysis that you're talking about here? Or is there interesting things coming up that would regulate predictive policing in the AI Act or in the surrounding legislation?
Yeah, actually today I didn't focus on the AI Act, but there are restrictions, especially which prohibit risk scoring, like the case in China, or at least also as per the data collection point, again, like there are restrictions on the use of face recognition technologies publicly by law enforcement. There are exceptions to that, but at least risk scoring is an issue, which is regulated within the AI Act. It's also important and relevant. But it's another question if we should still regulate them within criminal procedures, because we are really positivist in criminal procedure, meaning that we really want to have clear instructions for the police, clear instructions of prosecutors, judges, and so that we ensure the rights of the suspects are protected. So yes, we can have a general prohibition on risk scoring, but profiling can have many other aims also than just risk scoring. So we wouldn't be prohibiting all of these. And
okay, so there is there's potentially a prohibition of certain purposes, but not of the means.
Yeah.
Yeah. Okay, I see.
Of the means with that purposes, I would just correct that way.
Thank you.
Thank you too.
Does anyone have any question? I also have another question now. I don't want to dominate this space, but I feel the need to ask because you explained how in criminal procedure it is really important to have clear regulations. And for my PhD research, I was looking into like legal standards for AI evidence, and I learned that criminal procedure is a very specific field in the European law, in the EU law specifically. It is not harmonized. It is like there's a lot of like member states are really protective when it comes to criminal procedure. That's my understanding. So how do you see how we can have a maybe harmonizing EU level regulation to ensure AI's like to ensure that we have an answer to all these questions you raised from a criminal procedure perspective? Do you see an exception maybe when it comes to this topic, or should we not be that hopeful?
So what's special about criminal procedures is it's about the state's jurisdiction to ensure the public security and public order within the borders, because each state is, of course, each state has similarities, but they're unique in the way that there are other cultural conflicts, societal conflicts, so there are different types of crimes. And when it comes to criminal procedures, more or less, they have some standards to ensure which are also have to be in line with the human rights foreseen in the European Convention on Human Rights and so on. There are so many tools which ensure that they are on the same page with the principles. So law enforcement directive is also very crucial because it tells this is the least you should do. You should be doing it. So you should have this kind of laws which at least ensures this kind of rights. So it's really important to maybe make surveys and encourage the states to have these minimum standards. Then we will maybe reach some point. But it's impossible to have maybe exactly the same regulation for the evidential value of profiling tools or for the limits on profiling tools in each state. It's unrealistic. But if the regulations are different, and as a result of that, a suspect cannot really access to any information which incriminates him or her, then it would be a problem anyways. It would infringe the right to a fair trial. And that's why I'm expecting for the European Court of Human Rights or Court of Justice decisions on that case, because that will also enforce the states directly to regulate profiling a bit more precisely and more in line with human rights.
Thank you.
Thank you too.
You gave us some food for thought.
And
yeah, what you said at the end, referring to Lauren's PhD defense yesterday. So you said we would need like updated equality rules that only take into account the current protected grounds like race and your religion, your age, your gender, because now there are also unwanted discrimination on the basis of other parameters. But are you now advocating to put additional grounds in anti-discrimination law? And what kind of, how would you, I remember that Lawrence also struggled with giving very concrete answers to how to operationalize that in legislation. We all feel that things are wrong, but how can we get it right in legal terms? I mean, how would we, what kind of new grounds could we add to the...
Yeah, that's also the hard part. Yeah, nowadays I'm thinking of checking all the decisions on the courts of the European courts on discrimination, because they define first some special categories, but they extend it with some terms like which are not only about race, but we must have some standards, because otherwise you can say, no, I'm stigmatized as lazy person, so you can't just go to court for everything. So it's hard to put a line. No, I'm also thinking about it, and I don't have a solution yet, but I agree that we can't just say everything, so because it's then incontestable. But maybe we can think of about some characteristics which are not that subjective, which are not that individualist, which has also a bit group connotations, like economic status also it's in relation to society, because you can't define yourself as wealthy or poor if you don't take the average or if you don't look at the society. So maybe this kind of characteristics which can...
That is already a ground, I thought. Your financial status or economic status. I thought it was included in the list of relevant...
but not in the GDPR for sensitive data, but maybe in... And also in constitutions, actually, when we look at the equality and non-discrimination clauses, I mean, I don't know all constitutions by heart, but at least in Turkey, I know it starts with counting race, religion, and on similar grounds. So in most of the cases, the basic principles are not really, don't have these outnumbered characteristics, and we have these listed characteristics in more precise regulations like GDPR and Law Enforcement Directive. But for general applicability of to include more stereotyping, apart from economical ground, which is also listed in some of the regulations. Now I'm thinking of another example, like what could it be? Like being antisocial. It's a weird criteria maybe, but it's vaguely used here. So what is antisocial and why is it relevant? And if the person is not getting a job because he's found antisocial, so could it be also a discriminatory criteria? Depending on the job. I mean, of course, if you are going to become a professor, maybe it's a bit important that you are social, but...
Being a introvert or like not sharing anything on LinkedIn or Instagram. So
yeah, that's also what we were discussing today with the there was a presentation from psychology department, so about psychopaths. It's also, they have criteria like parasitic life. if they have this kind of life, I'm like, what is that? Like, if you don't wash your clothes, or what is that? Like, how do you mean? So we see that even in psychology, these terms are, I mean, maybe they shouldn't be defined anyways, but these are vague terms. But at the end, we use these criteria to feed data, and how they are decided also. How do they decide who is antisocial and social, and then feed these algorithms with this data? There's also another field, like how do we collect and categorize this as antisocial is a way. But if it is categorized like this, and if it is used not to give you a job or to decide that you are risky, then we should maybe also cut that part, not use antisocial as a way to segregate people.
That's also, I think, a very culturally driven thing, because there are cultures that have a more, let's say, introvert or reserved personality, and cultures that are more open.
Yeah, exactly.
So also, we discriminate between cultures in one way.
Yeah, that too. Yeah, maybe culture relative terms are also a bit risky in that sense, because you might be very antisocial in one country just because you said no 2 times to your friends to go out, but on the other hand, it might be quite normal somewhere else. Or yeah, these are all relative terms. But it was a hard question, but I promise I will really think about it, because it really interests me nowadays how to come up with new categories and how to make it a bit more objective, not culture relative or psychology relative in a way.
Thank you very much, Irmak. If we don't have any more questions from our audience, online or on site, I guess we can close this seminar. It was really interesting to hear your presentation and to hear this discussion. So thank you very much for sharing this with us. And we look forward to seeing you in our next seminar on the 13th of March. As Jan Tobias shared on the chat, it is about mixed nets and metadata privacy in the internet. 14th of March. Thank you very much. And yeah.
Thank you for your participation and for the questions and for the great moderation. So hope to see you on 14th of March then.
Bye.
Thanks a lot.